Welcome back. Let's bring you this now. The CCMA has published its long-awaited amendments to the rules for proceedings before the Commission. The Labour Relations Act forms were also published, this as a result of the amendments. Now, once enacted later on this year, the Labour Relations Amendment Bill will then amend several provisions in the LRA, and one change empowers the CCMA to provide purely administrative assistance to lower-paid employees in the delivery of notices or documents relating to CCMA proceedings. But another change then empowers the CCMA to make rules to regulate the consequences of a party's failure to attend conciliation or arbitration proceedings. So let's now speak some more about this with Labour specialist Magate Phala joins me this morning to take this conversation forward. But Magate, thank you for your time. Good morning. Firstly, what are the CCMA rules? What purpose do they actually serve, just for context purposes?
Good morning, Dumelo, and thank you for having me. You'll recall that the CCMA is a creation of the statute in terms of the Labour Relations Act. And now, the governing body and the CCMA itself, so they are empowered to formulate its rules for the conduct of the proceedings before the Commission itself. So now the purpose of these rules are to, mainly if you look at it, is just to ensure that there is regularity, there is order, and there is efficiency and consistency in the manner in which proceedings are conducted before the CCMA. So that is in the main what the rules are about. Yes.
So just speaking of the rules then, what are the key changes to note in these new rules?
Yes, no, thank you. Yes, there are very pertinent changes, key changes in terms of the new rules which came into effect on the 24th of April. And one such change is Rule 1A, which actually deals with the processing and handling of personal information. So you will recall that when a party refers a matter to the CCMA, there is a form, LRA form 7.11, 7.18, and all other forms depending on the nature of the dispute that they refer, that they fill in, and there is a personal information that they fill or they in those forms. So now this new rule 1A actually conforms to the provisions of the POPI Act, which is the Protection of Personal Information Act. And so this Rule 1A actually provides, sort of a guideline or a regulation around how the personal information of the parties should be handled. One other change is the change around what you call Rule 31C, which deals with the re-enrollment of a matter in case where a referring party or an applicant has failed to attend an arbitration. So you'll remember in the past, if a referring party or an applicant fails to appear at the arbitration, then what will happen in that instance is that the CCMA commissioner or the arbitrator will then dismiss the matter. So now what will happen in terms of the new Rule 31C is that the matter will no longer be dismissed, but it will be sort of removed from the role of the CCMA and put somewhere in the archives. And once a party comes forward and say, I had valid reasons why I did not appear at the CCMA, then there will be another form that they need to complete in order for that matter to be re-enrolled back on the CCMA roll.
Right. So those are, I suppose, some of the key rules that we have to take note of. But in your opinion, how will these changes then benefit CCMA users, especially if we talk of ordinary employees in this context? Are there any benefits for them?
Yes, there are very much benefits, especially around what I've just what I've just alluded to in terms of protection of, personal information, re-enrollment of the matter. There is also guidelines around There's also the rules also provides clarity around application for postponements of an arbitration hearing. They also provide guidelines or clarity regarding, the payment of an arbitration fee in a case where the CCMA finds that a dismissal dispute was or the dismissal by the employer against one of the employees was procedurally unfair. Remember, the CCMA, in terms of Section 140A of the Labour Relations Act, is empowered to a fee if it finds that the employer has acted procedurally unfair.
All right, Magate, unfortunately, we have to leave it there for now due to not only time, but also because we understand President Cyril Ramaphosa has just made his way to the union buildings. I have to leave it there. And thank you, our labour specialist, Magate Phala, for speaking to us about issues surrounding the changes at the CCMA.